Hello boys and girls, this is CA Praveen Jain and you are watching me on my YouTube channel. In this video, I am going to detailedly analyze your CA Foundation May 25 law paper. So I will try my best to give the most accurate answers for this particular paper, and also we are going to see how the answers were supposed to be presented. Now most of the times what we will be observing is one liner, two liner answers anybody is able to write, sir. But the thing is, what is ICAI expecting from you? Even that paper presentation also I'm going to discuss in this particular video. So May 2025. So obviously CA student did not receive a question paper, but they have received a question book. Now totally there were around 24 questions, and these 24 questions were divided into 6 parts, or you can say 6 questions made. In these 6 questions, 24 sub questions were there, sir. Obviously one was left to be choice, sir. So totally, if at all you leave one question for the choice, so 4 questions are left. So somewhere around 20 questions you were supposed to write, sir. Now question 1 was compulsory, and remaining out of 5 you were supposed to write 4, sir. So totally the paper was for 126 marks, because in 6B also division was made. So totally paper was for 126 marks, in which student was supposed to attempt for 100 marks. So let us see question number 1. ABC Infrastructure was running business successfully for several years. P was the purchase manager of the company. He authorized his agent Q to buy raw material on his behalf for construction of road in Delhi. He instructed Q to buy only Mazboot brand of cement for 2000 to 2500 per ton to maintain the quality of roads in Delhi. However, Q brought 1000 tons of Mazboot brand. So obviously he has purchased the same brand, and he has purchased from Mr. R, who is a well-known vendor, but he has purchased for rupees 3500 per ton. So obviously, can I say principal has given, now who is the principal here, sir? Mr. P, that is nothing but company. On his behalf, P is acting as the principal. So principal has appointed an agent. Principal has given authority to an agent. He was, you are going to buy Mazboot brand of cement, that too between 2000 to 2500. But can I say clearly, you can see here agent has exceeded his authority, sir. Now Mr. Q has not disclosed the fact to the R that he was buying cement for ABC Infrastructure Limited. Now one of the rule what we understand is, if at all a person is acting as an agent, so whenever he is concluding a contract on behalf of principal, he has to ensure that that contract is signed by him on the name of the principal. In other words, he has to disclose the name of the principal in the contract. And if he does not do, it will be assumed that he is entering this contract on his own behalf and not on the behalf of principal. So can I say here he has made this mistake. Actually, he wanted to enter into a contract. He wanted to bind principal and Mr. Q, but principal and Mr. R, but at the end of the day, he did not mention the name of Mr. P. So obviously, this could be a contract between Mr. Q and Mr. R, sir. Now, when P discovered this aspect, he refused to pay Mr. R and rejects the cement brought by Mr. Q on the ground that Q has exceeded his authority, which is fair enough, sir. R has suffered a huge loss. So obviously R has given a commitment. What R has given a commitment, sir? He is going to sell the cement for rupees 3500 ton to Mr. Q, and now Q is not buying, and ABC Limited, that is Mr. P, also does not want to buy, sir. Now give your opinion in accordance with the provisions of Indian Contract Act. Whenever in foundation or in any exam, sir, if at all you are solving any problem, you have to see under which law this question is asked for. So very clearly it is mentioned that you have to give answers based on Indian Contract Act. So 2 questions are given. Whether P was bound to pay Mr. R for cement purchased by his agent Mr. Q. On the other hand, Q, being the agent, refused to accept any liability to compensate R. In this situation, whether R can file a suit against Q. Now, if at all I have to give you single line answer, can I say whether P is bound to pay R for the cement purchased by his agent Mr. Q? Obviously, when Q has signed the contract, he did not mention the name of the principal. So as such, there is no contract between P and Mr. R. So hence, when there is no contract, Mr. P need not pay any money to Mr. R, sir. Can I say this could be the one-liner answer, but you have to write this in line with Indian Contract Act. So you have to see what provisions are getting triggered in this particular point, sir. That's the reason I told you I am giving you presentation part also in this particular video, sir. And because anyway your CA foundation exams are over, so can I say you are having abundant time, you can obviously watch this complete video to get better analysis. And more importantly, people who are going to write the coming exams, they have to watch this video very thoroughly to ensure that they get a proper kick for your next exam, sir. Now, so first question ka answer is what, sir? Principal is not bound, sir. But how we are going to write this in the exam? Because it was a 7-marker question, sir. So as I told you in the class also, sir, whenever we get case study or application based questions, we have to divide the answer into several parts. First part we are going to write the facts of the case, sir. As such, I told you for 4 marks, 5 marks, or what do you say, lesser than 4 marks, sir, facts of the case need not be written. Reason is abundant time is not available, sir. Time is very, very less in the exam. But because it is a 7-marker question and because this is a first question, it is always preferable to write the facts of the case, sir. So whatever was the question, sir, uska shorter version, condensed version, I have written here, sir. Because I have already read the question, this is for you to read it, sir. Now, step number 2 is what we have to talk about is provisions as contained in the Contract Act. So you can see relevant provisions contained in the Contract Act. So because I am giving answer for first question, here I wrote first point, sir. Now here, what are the relevant provisions, sir? So 3 sections we have to refer. One is section 226, 227 and 228. Now, if you can write section numbers, that is fair enough. And even if you could not mention, sir, if you mention the provisions properly, that is also a done deal, sir. Now, section 226, what it says, sir? Contract entered into by the agent within the scope of their authority bind the principal, sir. So whenever agent is entering into any contract with the third party, if he is entering into a contract within the scope of their authority, then he is going to create a contract between principal and third party, sir. Obviously here, by looking at this section, very clearly we can say that above thing Mr. Agent did not do this thing, sir. 227. When an agent does more than he is authorized to do, sir. So 226 is saying what, sir? When agent is going to bind the principal. 227 is saying what, sir? If at all agent goes beyond his authority, sir, that is agent does more than he is authorized to do, and the part within which his authority can be separated from the part outside it, meaning he has done some transaction for which something was authorized, something was not authorized, and that part can be separated, sir. Okay, the principal is bound to the extent of, the principal is bound only to the extent of the part which is within the authority. So in other words, if within authority part can be severed with outside authority part, then within authority part ke liye principal is liable, sir. Okay, section 228, if the unauthorized part of the act cannot be separated from the authorized part, the principal is not bound at all, sir. Now can I say in this case, principal, that is nothing but what, sir? Mr. P, purchase manager of ABC Limited, sir. Can I say he has given the authority to the agent to buy the cement at 2000 to 2500 per ton, sir. And can I say here you cannot find things which are separable or inseparable, sir. In other words, it's an absolute contract, sir. So obviously 228 will also get attracted. Now, because this part cannot be separated, sir, in such a way, sir, can I say principal is not at all bound by the contract, sir. That is how you have to write. Step number 3, application of above provisions. So step 1 was what, sir? You wrote the facts of the case. Step 2 was what, sir? You wrote the relevant provisions in the Contract Act. And step 3 is what you are going to apply those provisions in the above portion, sir. Q was authorized only to purchase at rupees 2000 to 2500 per ton. Q purchased rupees 3,500 per ton, which is beyond the scope of his authority. The price is a material term and it cannot be separated from the rest of the contract, sir. Moreover, Q did not disclose that he was acting for ABC infrastructure, which means R believed Q to be the buyer, sir. So what is the conclusion? Step number 4, sir. So can I say here we have properly applied section 226, 227 and 228, sir. So ABC infrastructure is not bound to pay Mr. R. Why? Not bound to pay Mr. R because he has exceeded his authority. And can I say in this transaction, Authorized part and unauthorized part cannot be separated. Hence, when it cannot be separated, entire thing will become void, sir. So P is justified in rejecting the purchase as Q exceeds his authority and the unauthorized act cannot be separated. So this is how you are going to write the answer, sir. So this was point number 1, sir. Now let us see second question. What was the second question? On the other hand, Q being the agent refused to accept any liability to compensate R. Now can I say this is not allowed? Mr. Q, you are now entering into a contract on your own name. You did not disclose the name of the principal. So as a situation mein, what we will believe is you are entering into a contract with Mr. R. So in this case, obviously Q has to honor this contract, and if it does not honor this contract, whatever damages Mr. R is going to face, he can recover this from whom, sir? Mr. Q, sir. Now you can see this part also. So can Mr. R, third party, sue the agent, sir? Relevant provision, sir. Again, section 230. An agent is not personally liable. So can I say this is a general rule? Whenever agent is entering into any contract with the third party, he is never personally liable to the third party, sir. But yes, he is answerable, liable to the principal, sir. But can I say all this is possible only when he discloses the name, sir? Now, but the agent is personally liable in the following cases. What are those two cases, sir? First, if he does not disclose the name. Second, he exceeds his authority. And can I say here, the bumper thing is he did both the mistakes. Law is saying any one of the thing you are committing as a mistake, then Mr. Agent, you are personally liable. But can I say in this case, Anna has done both the mistakes, sir. Now, applying the above provisions, Q did not disclose that he was buying on the behalf of ABC. Hence, under section 230, he is treated to have contracted personally with Mr. R. ऐसे situation में there is a valid contract between Mr. Agent and Mr. R, and if at all agent is not honoring the contract, sir, R can file the suit against Q, because we have studied section 2 clause H. What is a contract? Contract is nothing but an agreement enforceable in the eyes of law. So here, who is going to enforce this agreement, sir? Mr. R is going to enforce this agreement. This is how you are supposed to specify the answer in the exam for a 7-marker question, sir. Obviously, can I say little bit of condensed manner may you can write the facts, but otherwise provisions part you have to mention in this manner. If you do like this, sir, then 7 marks will be printed on your answer sheet, sir. Now let us see second question, sir, 1B. Now in this 1B, again there were two subparts, sir, 1 and 2, and this was a question from Companies Act, sir. Okay, now this question was a bit tricky, sir, and maybe can I say when you were studying at that time you could have full clarity, sir, but just say you write the exam paper, sir, at that time can I say we become completely blank. What minute mistakes which student could have committed, let us try to see, sir. State with the reasons whether the following companies can be treated as a small company. So now can I say B1 is talking about small company. So here there are two companies which are specified, sir, and we have to find out whether these companies are small company or not. Whenever this type of question comes, sir, read the question. I'm not saying don't read the question, sir, but don't try to give conclusion on the paper, sir. If you try to give conclusion on the paper, there is a high possibility we may commit mistakes. So better thing is what, sir? Now you know that this is a question relating to small company. So it is advisable first you write down the definition of small company. So can I say section 2 clause 85 defines what is a small company. So small company means what, sir? That company which fulfills the following conditions. Obviously small company should be a company fulfilling following conditions. So here we are having two conditions. One condition is with respect to paid up capital, another condition is with respect to turnover, sir. Now paid up share capital should be how much, sir? So paid up share capital should be 50 lakhs or such higher amount as may be prescribed. Obviously prescribed matlab it will be prescribed in the rules. And is there any higher amount prescribed by central government in the rules? Answer is yes. Currently the amount is 4 crore rupees, sir. Okay, so limit given in the act was 10 crores. So central government can prescribe a higher amount but not higher than 10 crores. So currently they have prescribed 10 crores as the paid up share capital. Similarly, turnover should be 2 crores or such higher amount as may be prescribed. Again, they will be prescribing the rules, sir, but that amount cannot go beyond 100 crores. Did they currently specify? Answer is yes. As per the rules, the limit is 40 crores. So frankly speaking, literally speaking, today, can I say if you want to be called yourself as a small company, sir, then your turnover should not go beyond 40 crores and your paid up share capital should not go beyond 4 crores, sir. So this is the limit which you have to remember, sir. But in exam mein, you have to mention like this, sir. Plus, can I say certain companies will never enjoy the status of a small company? One, if you are a public company, then you cannot be called as a small company. If you are a holding company, you cannot be called as a small company. If you are a subsidiary company, you cannot be called as a small company. If you are a Section 8 company, you cannot be called as a small company. Or you are a company which is governed by any special law, sir. You are governed by any special law, then also you cannot be enjoying the status of a small company. Now, this is your full-fledged answer for small company, sir. Now with this, now try to apply to the particular question, sir. So can I say STS is a private limited company, turnover is 10 crores. Actually we wanted turnover up to 40 crores, limit is allowed, sir. Can I say turnover limit is less than 40 crores? Pakka, good. Plus paid up share capital is 1 crore. Excellent. Can I say paid up share capital allowed by the law was how much, sir? 4 crores. Here it is only 1 crore. Okay, great. Out of these, 60,000 equity shares are held by UV Infratech Private Limited, sir. So can I say in this company 60% stake is held by UV Infratech Private Limited, sir. So can I say STS Private Limited becomes a subsidiary and UV Infratech becomes a holding company. And just say this fact comes, can I say they have fulfilled the numerical criteria, but they did not fulfill this particular criteria. Because our company STS Private Limited has become a subsidiary company and subsidiary company can never enjoy the status of a small company, my answer is STS Private Limited, you cannot be called as a small company, sir. Second, ZX Limited having a paid up capital of 3 crores. Can I say paid up capital allowed was 4 crores, sir. Here it is less than 4 crores. Plus turnover allowed was 40 crores. Here it is less than 40 crores, sir. Both the criteria are fulfilled, sir. But can I say here, most of the times where student will commit the mistake is reading this part, sir. Can I say it is ZX Limited, not ZX Private Limited, sir? Can I say which company can never become or never enjoy the status of a small company, sir? A public company. Because it is a public company, even if you fulfill all the criteria, still you cannot enjoy the status of small company, sir. Hence, even this company is also not a small company, sir. So answer is neither STS Private Limited is a small company nor ZX Limited is a small company, sir. This is how you are supposed to mention your answer, sir. Obviously, this conclusion ko more elaborate you can write, sir, depending upon the time and depending upon the marks for which it was asked. Because it was asked for only 4 marks, sir. So it is preferable to write the answer and then you can apply the provisions of Companies Act and give your conclusion, sir. Now, next question is the paid up share capital of ABCD Limited is 80 crores, great, and preference share capital is 20 crores, sir. Okay, so equity is also there and preference is also there, sir. B Limited holds equity shares in ACD Limited, sir. So there is a company called ACD Limited. In that equity shares are 80 crores. In that preference shares are 20 crores, sir. So in this company, B Limited is holding equity shares worth 15 crores. This is equity shares, sir, and preference shares worth 10 crores, sir. So preference shares are 10 crores. Can B Limited be considered as an associate company of ACD Limited, sir? So B, can it be associate? Obviously, can I say B is investing in ACD, sir? So obviously B is the influencer company, ACD is the influenced company, sir. Obviously, can I say if at all anybody has to be called as associate, that will be only B Limited, sir. But can I say to call yourself as an associate, there is a definition, sir. Definition is given in section 2 clause 6 of Companies Act, sir. So let us now try to find out what is the definition, sir. Again, can I say before jumping to the conclusion, it is always preferable to write the answer, sir. So when a company will be called as an associate company in relation to another company means a company in which the other company has a significant influence. Okay. Now, what is significant influence? Can I say significant influence is given in definition, sir. That is explanation part mein it is given. And that explanation is also forming part of section 2 clause 6, sir. Means a control of at least 20% of the voting power. So if you are having a control of at least 20% of the voting power, sir, then the opposite company ke upar you are having a significant influence, sir. Now the question is B Limited having 20% control, 20% voting power of ACD, sir? So can I say voting power mein what should be counted, sir? Equity should be counted, preference should be counted. Now generally remember this as a thumb rule, sir. Sir, whenever you are talking in a voting power, matlab kya? Where you are going to exercise your voting power, sir? In the general meeting, sir. In the general meeting, preference shareholders do not have any voting power, sir. So voting rights are only given to equity shareholders, sir. However, when you read section 43, kinds of share capital, there are two circumstances where preference shareholders will also have voting rights. But because such circumstances are not mentioned in this particular question, we will assume that preference shareholders are not having any voting rights. Hence, we are going to completely ignore preference share capital of 20 crores. So there is no question whether preference share capital is convertible or non-convertible. Whatever it is, whether preference share capital is convertible or whether preference share capital is non-convertible. Sir, convertible, matlab they are going to convert in the future. In future, they are going to get voting rights. So let us not bother today, sir. So hence, whether preference share capital is convertible or not convertible, that is irrelevant part for our exam, sir. So hence, we are going to completely exclude preference share capital from the perspective of voting power, sir. So now, voting power is for 80 crores, sir. So can I say 80 crores is 100%, sir. In that, what we want is 20% or more of the voting power, sir. So can I say 20% ke liye, you should hold at least 16 crores, sir. But here, in this case, company is having equity share capital of only 15 crores. So it is less than 20%, sir. Somewhere around 17.5 or 18% only they are holding, sir. So hence, I will just say B Limited is just a investor in ACD Limited, but B Limited is not an associate, sir. Okay. So this is how you are going to conclude the answer, sir. So at least 20% of the voting power, or if not that, if you're having a control or you're able to participate in the business decisions under any agreement, then also opposite company will be called as associate company. But can I say such facts are not given, sir? But which is not a subsidiary. Obviously, can I say significant influence will be somewhere between 20% to 50%. If it is 50.1, then opposite company will be called as a subsidiary company, sir. And it includes a joint venture, and joint venture ka definition is also given, sir. Because can I say in my present part, joint venture thing is not related, hence I am ignoring it, sir. So what is the answer, sir? Can I say 20% will come around 16 crores and you are holding only 15 crores. Hence, B Limited, you will not be called as a associate company, sir. Okay. So this was again a company law question for 7 marks. One was for 4, one was for 3. And this is how you are supposed to present the answer, sir. Okay. Let's go further, sir. Now, question number C was with respect to partnership, sir, and it was asked for 6 marks, sir. Now, this question was to some extent a straightforward question, sir. In accordance with the provisions of Indian Partnership Act, explain the following. What are the rights? What are the rights of an outgoing partner to carry on the competing business? When I say outgoing partner, can I say this partner is resigning the partnership firm and now he is leaving the partnership firm? Now, when you are leaving the partnership firm, what are the rights you are having, sir? Now tell me, sir, what are the rights he is having? Can I say if you leave the partnership firm, can you carry on the competing business? Answer is yes, sir. But can you use the trade name? Answer is no. That is firm name? No. Can you represent yourself carrying on the business of the firm? Answer is no, sir. Can you solicit the customers or other persons who were dealing with the firm before he ceased to be a partner? Answer is no, sir. In other words, little bit loyalty you have to maintain towards your ex-partnership firm also. In other words, Mr. Partner, Mr. Outgoing Partner, you can carry on competing business. However, these 3 things you cannot do. What are those, sir? You cannot use the firm name. You cannot represent yourself doing the business on behalf of the firm, because that you can do only if you are representing the firm. Now you are not representing the firm, hence you cannot do this. Similarly, you cannot solicit. Solicit matlab go, sir. Solicit matlab kya? Go after whom, sir? Customers or other persons with whom the firm was dealing when he was the partner. These things you cannot do. Now, the question is, can he carry on the competing business? Answer is yes, as per section 36 of Indian Partnership Act. But can I say, if you try to cross compare with Indian Contract Act Part 1 provisions, sir, that is nothing but general principles, sir. There you did study something called section number 27. Section 27 talks about what, sir? Agreement in restraint of trade. There you will be seeing what, sir? Ki agreement in restraint of trade. If any agreement is stopping you from doing any lawful trade, then that agreement will be void, sir. So obviously, can I say if at all you are stopping him, sorry, so your competing business you can do, sir. But imagine a scenario if a partnership firm is entering into an agreement, sir, with whom? Outgoing partner, saying that Raja, you are leaving our partnership firm for next few hours. Within this particular place, you are not going to carry on competing business. Now question is this allowed? Now can I say when you read only section 36, this is allowed, sir. But when you also read section 27, section 27 may, we have some exceptions, sir. And in that exception, one of the exception is this: if at all a partnership firm is entering into an agreement with the outgoing partner, specifying that outgoing partner is not going to compete with the firm, that is, he is not going to enter into a similar business, sir, and for a specified period within a specified limits, local limits, sir, then these type of restrictions we are saying as reasonable restrictions, sir. And if it is a reasonable restriction, sir, even though it is like an agreement in restraint of trade, this is permissible, sir. So all in all, what is the conclusion we have to find out, sir? Whether partnership firm has entered into this type of agreement, sir. What agreement? You should not carry on competing business. If they have entered into this type of agreement, sir, then now you cannot carry on the competing business. If this type of agreement was not entered by the partnership firm with the outgoing partner, then outgoing partner, you can bindas carry on your competing business, sir. So can I say this answer you have to cross relate with section 26 or 27 of Indian Contract Act and 36 of Indian Partnership Act, sir. Okay, I hope you have understood this point, sir. Next, then we are having another question, which is second part, sir. What are the rights of a partner to be indemnified? Means partner should get indemnified. And what are the liability of a partner to indemnify the firm? In other words, one part may we are talking about partnership firm indemnifying the partner. In another part may partner has to indemnify the partnership firm, sir. So can I say when firm is going to indemnify the partner, this will become his right. Similarly, when partner has to indemnify the firm, it will become liability of the partner, sir. Now where it is written, sir, now for that we have to refer. Now this answer I have given in a very condensed manner, sir. So now we have section 13 clause E and section 13 clause F, sir. So these are the part which is dealing with this particular aspect, sir. So 13E is talking about right to be indemnified by firm, and 13F is talking about liability to indemnify the firm. So now when the partner is having right to be indemnified, now tell me, when a partner is going to enter into any business contract, and if he is entering into a business expense on behalf of a firm, or he is taking some actions, emergency actions, as a man of ordinary prudence would have taken, sir, then don't you think whatever cost, whatever expenses, whatever liability partner is incurring, do you think firm is having the duty to reimburse that? Answer is yes. So whatever expenses, liabilities partner incur when he is representing the firm, and all those lawful expenses, all those emergency actions which he is taking as a man of ordinary prudence would have taken in his own case, sir, as a situation may partnership firm has to indemnify the partner, sir. This is what given in section 13E, sir. Similarly, sir, when a partner is acting with the outsider, sir, can I say if at all any losses the partnership firm get because of his willful negligence, because of his fraud, because of breach of duty? Because whenever you are acting as a partner, can I say we expect you to behave as a man of ordinary prudence. But here, are you behaving in a man of ordinary prudence? No, you are behaving negligently, you are doing fraud, you are doing breach of duty, because of which who is incurring loss? Firm is incurring loss, sir. As a situation may, can I say partner, it will be your liability to indemnify the partnership firm, sir. So this is one small answer, sir. Though I wrote in a condensed manner, but I explained you totally, sir. Now remember, sir, this video I am not shooting only to just quickly go through the answers, sir. Now here the main intention is to make you feel good and how to write these answers in the exam, sir. Question number 2A. So with this, we completely finish our first bit, sir. 776, that means first bit, which is compulsory question, which was asked for 20 marks, sir. Okay, great. where if at all anywhere trickiness was involved, I guess it was question number 1B, sir, where Companies Act ka provisions were there, sir. So here also there is a possibility and many students may commit mistakes, and here also there is a possibility student could have committed mistake, because can I say numbers are there. Now what will our mandbuddhi students do, sir? They are going to add them. 80 ikkada, 20 akkada, 100 crores it is, 20% is what we want, and here also they are holding that much, sir. Like that they may say, sir. Answer is not allowed, sir. Because equity was 15, preference was 10, 25 they are holding, hence it is 25%, hence it will be a associate company. No, nahi chalega, sir. Now let us see question number 2A. So there is S who has purchased some dress material and made a payment in cash. Great. Now this dress required some alteration, sir. Okay. The shopkeeper assured S that it would take 1 day to get the dress altered. Okay. So shopkeeper is asking for 1 day ka time limit, sir. Okay. And it was also agreed that once the dress was altered, the shopkeeper would inform the S. So can I say when this ownership is going to be transferred, sir? Can I say ownership is going to be transferred even though contract is entered, S has purchased the dress, S has made the payment, everything is over, still ownership will not get transferred. When ownership will get transferred, sir? When the dress material is altered plus the shopkeeper has to inform the customer, that is nothing but S. Can I say if two conditions are satisfied, then only ownership in the goods is transferred, sir. Next day by evening the dress was altered. Very good, sir. Can I say one condition is over, dress alteration is over. Now shopkeeper, your only job is to inform, and kept ready to be delivered to S. But the shopkeeper, however, forgot to inform S. Mandbuddhi shopkeeper, sir. Can I say shopkeeper, you are having only two duties to perform. One was alter the dress. Second was you have to inform about alteration to whom, sir? Buyer. Jaisi these two conditions would have been fulfilled, ownership would have been transferred to the buyer. But can I say you did not fulfill one condition, sir? That means is the ownership transferred? Is the passing of ownership occurred? Answer is no. That means who is still the owner? Shopkeeper is still the owner, buyer is not the owner, sir. In the meantime, what has happened? A short circuit has occurred near the delivery counter of the shop, and some packets ready for delivery caught the fire, sir. Oh, that means swaha. After waiting for 10 days, now S comes and wants to collect her dress. She was informed that she came late and her dress was burnt in fire. Now can I say our shopkeeper is giving a surprising news. Nana, you came very, very late. Great. Now can I say what is our buyer asking, sir? S, who is the buyer, is asking for the refund. Fair enough. Can I say when you can't deliver the goods, ownership was not transferred, so at least give me my money back. Fair enough, sir. But can I say shopkeeper, what he is doing? He is refusing, sir, saying that the dress was kept ready. Can I say kept ready is important? After that you have to inform also. You have to inform, sir. So he is refusing to bear the liability by saying that if S would have collected the dress on time, it would have not burnt. Ek to you committed the mistake, you are not accepting the mistake, and now you are saying that buyer has committed the mistake. Very good shopkeeper, excellent shopkeeper. S, who is nothing but buyer, insisted that she was waiting for a call. Correct, na Raja? I was waiting for your call, sir. Ki bhaiya, when you call and I will come and collect it. You did not call, I did not come, sir. And thus entitled to claim refund, sir. Examine with the reference of provisions of Sale of Goods Act whether shopkeeper will be liable to refund. Can I say all the logical reasoning I have already given, sir. Shopkeeper, you are still the owner, because if at all the passing of ownership has to occur as per section 19, if at all ownership has to be transferred, it was your duty to complete your obligation. What was your obligation? One is to alter the dress and second was to inform. You altered but you did not inform. That means you did not fulfill your obligation. Because you did not fulfill your obligation, sir, you are still the owner. You are still the owner, sir. And because you are the owner, as per section 26 of Sale of Goods Act, we believe that always risk follows the ownership. Because you are the owner, you have to bear the risk, sir. As the situation may, risk still remained with the shopkeeper, sir. Hence, shopkeeper, you have to provide the refund or pay for the damages, sir. So let us see this answer, sir. So here, if at all somebody really apply brains, how many sections ka cross references are required? 19, 21, 26, 33 and 36, sir. Let's see how it is, sir. Passing of ownership or transfer of property constitutes the most important elements to decide the legal rights and legal liabilities between sellers and buyers. Passing of property is nothing but passing of ownership. If the property is passed to the buyer, that means risk in the goods will be sold. Risk in the goods sold is that of buyer, sir, and not of seller. Though the goods may still be there with whose possession, sir? Seller's possession. In other words, if the property is passed, then who becomes the owner? Buyer becomes the owner. Even though the goods are in the possession of whom, sir? Seller. Still, who is not liable? Seller is not liable, sir. Imagine if at all seller has completed his obligation, he has informed also, sir. Still buyer did not come and collect, and then if at all fire has catched, sir, as a situation may buyer, you have no right to claim any compensation, no refund is allowed, sir. But here buyer was not at mistake. Who was negligent, sir? Seller, and hence seller has to suffer, sir. Now again, can I say, because this answer is also for 7 marks, again I wrote facts of the case, sir. You can quickly go through, sir. Then step 2. Now exam may don't write step 1, step 2, sir. This is only for your understanding, sir. Step 2 may, what are the relevant provisions, sir? Section number 19. Sir, 19 talks about transfer of ownership. The property in the goods. When I say property in the goods, it is nothing but ownership in the goods is transferred to the buyer at such a time as the parties to the contract intended to be transferred. In other words, ownership will be transferred to the buyer. And when this ownership will be transferred, sir, you have to see their intentions. And question is, how we will come to know about their intentions? Maybe you can refer the terms of the contract, maybe you can refer the conduct of the parties, and maybe you can refer the circumstances, sir. But can I say here, terms of the contract, say you can understand, sir. What are the terms of the contract, sir? Ki bhaiya, buyer is going to get full ownership in the goods only if obligation, specific goods they are, only if obligation is fulfilled. Of whom, sir? Seller, sir. Now here obligation was not fulfilled, sir. Next, specific goods to be put into deliverable state, sir. Can I say goods are specific, dress material is specific, but that goods has to be put into deliverable state. What do you mean by deliverable state, sir? You have to do the alteration and inform, sir. Where there is a contract for sale of specific goods and the seller is bound to do something to the goods for the purpose of putting them into deliverable state. So you are bound to do something, sir. What you are bound to do something here? Nothing but alteration, sir. The property does not pass until such thing is done. So here, Mr. Seller, 2 things you are supposed to do. One is alteration, second is information, sir. Matlab, you are supposed to inform the buyer कि goods were altered. You performed this duty, you did not perform this duty. Until such thing is done, the buyer, the property will not pass. And if the property does not pass, the risk will also not pass. That means seller will be still the owner, sir. Then the answer is what, sir? Mr. Seller, you have to compensate, sir. That is what the question was. Whether shopkeeper is liable to refund? Answer is yes, sir. So that is how you are supposed to write the answer, sir. So conclusion, by applying the above provision, shopkeeper is liable to refund the cost of dress to the buyer, sir. That ends that particular part, sir. Now let us see question number 2B, sir. Now question 2B was asked from Companies Act. Again, beautifully 7 marks it was asked. Doctrine of indoor management allows all those who deals with the company to assume, that is presume, that the officers of the companies has observed the provisions of the articles. In light of the above statement, explain the doctrine of indoor management and also specify exceptions if any, sir. In other words, it is actually a direct question only, sir, but to make it look like case study, sir, they have just put some additions to it, sir. So in other words, they are just asking you write short note on doctrine of indoor management and write exceptions, sir. Now can I say very beautifully they wrote if any. Answer is exceptions are there, that is there in the study material, sir. Now can I say in our syllabus we are having 3 doctrines, sir. One was doctrine of ultra-vires, one was constructive notice, and one was indoor management. Can I say indoor management was nothing but an exception of constructive notice, sir. What is indoor management doctrine saying, sir? As far as internal regularities are concerned, outsider, whenever he is dealing with the company, if he is having the knowledge of memorandum, articles, and no knowledge of internal irregularity, sir, then ऐसे सिचुएशन में he can presume that whatever compliances are supposed to be done internally, है ना, he can presume that they are duly complied with, sir. In other words, this doctrine is going to protect whom from whom? This doctrine is going to protect outsider from the acts of the companies, sir. So that was the major funda behind introducing doctrine of indoor management, sir. Now, remember, don't write any section numbers, sir, because doctrine of indoor management was laid down in a famous case law which was Royal British Bank versus Turkand, or indoor management is also called as Turkand's rule, sir. And I hope you remember this point, sir. So doctrine of indoor management is a key principle in the company law which serves as an exception to doctrine of constructive notice, which we already know, sir. The doctrine of indoor management is protecting whom, sir? Outsiders, sir. When it is protecting, sir, when the outsider is acting in good faith. What do you mean by good faith, sir? Imagine if the outsider is having knowledge of internal irregularity and still he is entering into a contract, sir, then as a situation may outsider cannot take the benefit of what, sir? Indoor management. Why? In that case, doctrine of constructive notice will apply, sir. Because when you are having the knowledge, still you are entering into the contract, that means you are ready to bear the obligation, sir. Okay. So indoor management allows them to assume that internal procedures of the company are properly followed, sir. In other words, as far as internal regularities are concerned, outsider can assume that they are duly complied with. Outsiders need not investigate. They may assume, there is for outsider, that regularity in the acts done by the officer acting under the apparent authority. The doctrine supports commercial transactions, protecting third parties from the internal irregularities. However, protection is not absolute. It is having some exceptions. Now, what are the exceptions, sir? First point, sir. Now, tell me, sir. If the outsider is having knowledge of irregularities, then is he acting in good faith? No. Can I say, in that case, indoor management benefit nahi milega. Outsider is having no knowledge of AOA, MOA, sir. Then, do you think he is going to get the benefit? No, he is not going to get the benefit, sir. Imagine if the transaction is done and it is done involves a forgery, sir. Can I say, we have seen a very popular case law in this particular point also, Reuben versus Great Bengal Consolidated Company case, sir. So whenever forgery is involved, here free consent thing is there or consent itself is absent. Consent itself is absent. Hence, such type of things will be void ab initio, that is null and void from the beginning. Then also outsider, you will not get any benefit, sir. Or if at all outsider is doing any transaction with the company, sir, and there some suspicions are there, sir, then as a situation may you are having duty to inquire. And if you don't do that, sir, as a situation may, again we will believe that outsider is negligent, sir. Here the reference of Anand Bihari Lal case law can come, sir. So this was your 7-marker question, sir. So this was indoor management, sir. Next, 2C. Again in 2C you are having bits, sir. LLP gives benefits of limited liability. Yeah, LLP gives benefits of limited liability of a company on one hand and flexibility of partnership on the other. Discuss according to the provisions of LLP Act 2000. In other words, this point is talking about what, sir? If you are forming an LLP, you are getting benefits of company. You are also getting flexibility of partnership. In other words, you are getting dual benefits, sir. So on that short note, we are supposed to write, sir. Now, this is there in the starting pages of your LLP Act, sir. Now, again, better presentation I have given here, sir. So, LLP combines benefits of both company and partnership firm. So, in other words, whenever you form a LLP, you get a dual benefit, sir. Now, what are the dual benefit? Limited liability like that of a company, operational flexibility like that of a partnership. How? Let us see, sir. Limited liability, sir. Can I say, if at all you form a LLP, whoever are the partners, they are not personally liable for LLP debts. If at all you form a LLP, sir, partners' liability is limited to the agreed contribution, sir. And creditors, you cannot sue the individual partners, sir. Can I say, these are all the benefits which a member gets in forming a company. These are all the benefits which a partner gets by forming a LLP. Such benefits were not available in partnership firms, sir. Similarly, partnership firm में some benefits are there, sir. What are the benefits, sir? Can I say all the duties between partners? Can I say partners can mutually decide in the same manner? Sir, whatever are the obligations, rights, duties of partners in LLP, sir, LLP Act is giving full authority to whom, sir? Partners. By you decide your duties, you decide your roles, you decide everything, sir, by mutual agreement. So can I say what benefit a partner would have got in a partnership firm, same benefit a partner is also getting in LLP, sir. Similarly, can I say board of directors requirements and a board meeting requirements, such type of compliance part is not there in LLP, sir. Similarly, law compliance burden is also very less, sir. Filings, etc. When with filings, etc., which are required to be done for company and filings, etc., which are required to be done for LLP are also very less, sir. So similarly, audit norms, there is a relaxation for LLP, sir. Such relaxations are not there for a company. Irrespective of a turnover, sir, you have to get your books of accounts audited, even if you are a dormant company, sir. But can I say LLP may you are having certain relaxation. So operational flexibility is also available, sir. So this is the dual benefit, sir. Second question, sir. So Raju and his friend Anil has approached you to form an LLP. Very good. The object of LLP is to run a charitable school which provides free education. Acha, they want to provide free education. For that, they want to form a LLP, sir. What would be your suggestion, sir? Because you are helping them in incorporation, your suggestion is important. If at all you see section 11, subsection 1, clause C, uska synopsis I am giving you, sir. Whenever you form an LLP, at least two partners are required. Great. And those two partners are agreeing to carry on a lawful business. Great. But they are agreeing this to carry on a lawful business with a purpose, with a motive. What is the motive, sir? Your motive is to make a profit, sir. But can I say here they want to form LLP not to make profits, but they want to do some charity by providing free education, sir. So do you think can they do this? Answer is yes. But can they do this by forming an LLP? Answer is no, sir. Then as a situation, what are the options available with them? Maybe they can go with section 8 company, maybe they can form a trust, or maybe they can form a society. But which form of organization is not allowed, sir? LLP form of organization is not allowed, sir. This ends this particular part, sir. Next, 3A. So with this, question number 2 is also over. 20 plus 20, 40 marks are over, sir. ABC and company is renowned partnership firm doing business in textile industry, sir, for 20 years. But due to technical upgradation, firm has incurred a heavy debts of 50 lakhs. To maintain the integrity of the firm, they have introduced Mr. D as a new partner, sir. So can I say losses are there, reputation day by day is coming down, sir. Maybe D is a man of reputation, sir. They are bringing the new partner, sir. Before admission of D, other partners A, B, C decided on their own and made an agreement with the creditors that new partner will be liable for the existing debt through novation, sir. Wow, that means whatever are the pre-existing debt. What do you mean by pre-existing debt, sir? All those debts which are incurred by the company before introducing a partner, those debts I am naming as pre-existing debts, sir. So existing partners are entering into an agreement with the creditors saying that all those pre-existing debts ke liye, who is also liable, sir? New partner, that is D is also liable, sir. Okay. But the point is D was completely unaware about all these things, sir. Now who joins? D joins, sir. He comes to know about the debt of 50 lakhs, sir. With reference to the provisions of Indian Partnership Act, give your opinion whether D would be liable for the debts of the firm. Answer is no. Can I say if novation has to happen? What do you mean by novation? Substitution of contracts, sir. Can I say substitution of parties are happening, sir? If at all you want to do novation, in that agreement, who should also be there, sir? Can I say new partner should also be there, sir? Old partners, creditors are entering into an agreement saying that for existing debts, all those liabilities ke liye, new partner will be held liable. Can I say when you are making him liable, can I say his opinion also matters? Now, you did not take his opinion only, you did not take his consent only, sir. And as a situation, this is not a proper novation, sir. Hence, a new partner, incoming partner who is completely unaware about this particular thing, and he will not be held liable, sir. So answer is not liable, sir. Section 31, subsection 2, to be precise. An incoming partner is not liable for the debts incurred before his admissions. But yes, incoming partner may be liable, sir, when if he agrees to be liable, sir. Can I say his consent was required, sir. and the creditors consent to this arrangement. So here creditors consent is obtained, but his consent is not obtained, sir. In this case, ABC has made an agreement with the creditors that D would be liable for the past debts through novation, but D was not a party to that contract, sir. Hence, the conclusion is D would not be liable for what? Existing debts of the firm, just because existing partners and creditors agreed. D's consent is compulsory, sir. And without his consent, either expressly or impliedly, agreement has no binding effect on him. In other words, there is a privity of contract. Privity of contract means what, sir? Only parties having contractual obligations can sue each other. He is not a party to the contract. Hence, he is a third party, sir. He is a stranger to a contract, sir. Not allowed, sir. Similarly, next question is whether your answer will be different if D was a minor. Now tell me, sir. Can I say as a major only he was not liable? How he will be liable if he is a minor, sir? I see. What is this? Whether D would be liable to pay the debt upon becoming major. Now tell me, sir. Can I say as a minor you are not liable? How you will be held liable when you are a major? So obviously, if you think like this, then the answer is what, sir? Answer would remain same. That means D as a minor is also not liable. D as a major is also not liable, sir. But here, to elaborate this answer in a more better manner, what I am assuming is this. Imagine second part mein what is happening. When D is joining the partnership firm, at that time, imagine his consent was obtained. That means novation mein he was also a party to the contract, sir. In other words, D was having knowledge of the pre-existing debt, sir. Then is he liable? Like that, if we try to do, sir, some discussion is possible, sir. So let us see, sir. Is he liable, sir? Can I say for that we have to refer section 30 of Indian Partnership Act, sir. Now, can I say there could be a concept of full partner, though such wordings are not there in our ICI textbook or in the law also. You don't use the word called full partner. But generally in class, I do use this word, sir. What do you mean by a full partner? Can I say whenever you are a partner, you will be having certain rights, you will be having certain duties or liabilities. Now, if you are a minor, can I say you will be only having certain rights, you will never have any liabilities. So hence, minor is not a full partner. He is only admitted for what, sir? Benefits, and not for what, sir? Liabilities, sir. That is the reason I say minor is not a full partner. Minor is only admitted to the extent where benefits are there. Minors can be taking that benefit, sir. Hence, minor I don't call as a full partner. That's the reason I use this language, sir. Minor cannot be a full partner, but he may be admitted to the benefits of existing partnership with the consent of all the members, sir. Okay. A minor, now tell me, if you are making minor as a partner now, minor will not incur any personal liability for the debts of the firm, sir, because he was only admitted for the benefits of the firm. He was not admitted to incur any personal liability. His liability will be limited to the share in the partnership profits and property, sir. In other words, whatever benefits he is incurring, to that extent he will be held liable. You cannot take his personal properties, whereas for other partners, they are personally liable also, sir. And this is the provision if you make minor as a partner, sir. So conclusion, D was a minor at the time of a admission. He would not be personally liable for the debts of rupees 50 lakhs. Correct? It is a pre-existing debt, sir. Even if there is an agreement. In other words, even if there was a novation, even if it was told that he is going to accept the liability, but as a situation may, still minor will never accept the liability. In other words, minor does not have a capacity to contract, sir. Then why outsider? Who is this outsider, sir? Creditors, correct. Why creditors? You are entering into contract with such type of person, sir. Not allowed, sir. Hence, his personal assets are protected, sir. Next, whether D would be liable to pay debt upon becoming a major, sir. Assume D has agreed for a pre-existing debt. At that time, he was a minor. Later on, he became a major, sir. Is he still liable? Answer is no. Can I say as a minor, he was not liable, personally liable for pre-existing debt. Obviously, when he becomes a major also, he will not be liable, sir. But whatever are the debts which LLP incurs after the admission of minor as a partner, sir, for that will he be liable? Answer is yes, sir. For that, again, the answer can be given in this manner. But I don't think this answer was expected from ICI, sir. just for giving better clarity, I have included this scenario also, sir. As far as I am concerned, sir, ICA ka answer could be like this only, sir. Ki minor is not liable, even after becoming major also, he is not liable for the pre-existing debts. But I just elaborated this answer for your better understanding, sir. Now, section 30, subsection 5 says what? You are a minor, now you are becoming a major, sir. Now, are you continuing as a partner or not continuing as a partner? You have to take this decision within 6 months, sir. So when a minor attains a majority, he has 6 months to decide whether he wants to become a full partner. When I say full partner, now you will be also having liabilities, sir. If he does not give public notice within 6 months, he is deemed to be the partner of the partnership firm, and when from the date of his original admission as a minor, sir. In other words, backdated we are talking about, sir. In the given case, two scenarios are possible, sir. What are those? Maybe he will give public notice and maybe he will not give public notice. If he gives public notice saying that he opt not to become a partner within 6 months, he will not incur any personal liability. But if he accepts, he wants to continue, sir. Matlab, he is giving a public notice saying that I want to become a partner, or he fails to give public notice. Can I say? If he accepts or fails to give public notice, still we are assuming that you are a partner, sir. ऐसे situation में he becomes personally liable even for the past debts from the date of admission as a partner, sir. So conclusion, Mr. D would not be personally liable for pre-existing debt. That means debts before he becomes a partner. But yes, he will be liable for all those debts which a firm incurs from the time he entered or joined the partnership firm, sir. Okay, na? So that is the point, sir. Question number 3B1. The object clause of memorandum of ABC Limited authorized the company to carry on. So object clause is there. It is saying company you can carry on trading in properties. Since the company was not doing well, directors of the company in the recent board meeting have planned to diversify the business and they want to now enter into a construction business. Great. Can I say object is saying Nana do only trading in property, but they are doing what? Overaction. What they are doing, sir? They want to enter into construction business. Very good, very good. Karo, acha hai, very nice, sir. And only decided to enter into construction business, or they have borrowed also. They have borrowed 5 crores from whom? Magnum Finance Limited. Very good. Can I say Magnum Mandabudi company? But the members of the company did not approve the decision, sir. Obviously, of the board. Hence, the company refused to repay the loans. Money also taken, loan also not repaid, sir. According to the provisions of Companies Act, what is the recourse remedy available to Magnum Finance Limited, sir? Now, center of attraction is what, sir? The lender, the company which has given the money, sir. What is the remedy they are having, sir? Can I say, literally speaking, one chamat we have to put to whom, sir? This particular company, sir. Can I say, Mr. Lender, you are supposed to see the memorandum articles of this company, sir. When you read the memorandum articles of the company, can I say you would have come to know the object clause is clearly saying that they can deal only in what, sir? Properties. They cannot do construction, sir. Can I say you are supposed to have the knowledge of memorandum? And even if you are not having the knowledge, we will still assume that you are having the knowledge. Can I say doctrine of constructive notice, section 399, and that point is there, sir. So literally speaking, you should not get any remedy, sir. From whom? Company. But can you sue the directors? Yes, directors will be personally liable in this particular case, sir. So this is one way of answering, sir. But I just gave more elaborated answer, sir, here. Now, can I say section 4 is talking about object clause, sir? What it says, sir? The object mentioned in MOA, objects mentioned in MOA defines the scope of the company. Any act which is done beyond the scope of the company, we are calling this as a ultra virus transaction. And in above case, it is an ultra virus transaction, sir. And decided case law is what, sir? Ashbury Railway Carriage Company versus Ritchie, sir. If a company acts beyond the scope of memorandum, sir, it is an ultra virus act and it is void ab initio. And it cannot be ratified even by all the shareholders in the general meeting. Reason? It is ultra virus the director, sir. Ultra virus the acta. It is ultra virus the act, sir. And whenever anything is ultra virus the act, it cannot be ratified, sir. and these types of contracts are void and they are not binding the company, sir. But any recourse is there, sorry, let us see the implications, sir. What are the implications? Jaise you say this contract is void, sir. Now what will happen, sir? ABC is not legally bound to repay. But however, are there any remedies, recourse available to Magnum Finance Limited? Answer is yes, sir. So what are those remedies, sir? Remedy number one. Sir, first we will go in the order, sir. Now there will be some points which will be not there in the ICI textbook, sir. But the point is, can I say these things when we were discussing CA Inter, sir, doctrine of ultravirus, doctrine of constructive notice, doctrine of indoor management used to be part of CA Inter syllabus earlier also, sir. So these points were discussed in inter syllabus, sir. But the point is, these points are not discussed in your foundation, sir. But if you want to have full knowledge, you have to know about these points also. Whenever we are taking the class, when I was taking the class, sir, people who have taken classes from me, you might be knowing all these points I have discussed in the classes, sir. So that's the reason I am discussing, sir. If at all you are writing this answer purely from ICI textbook point of view, sir, this point was more than enough, sir. But anyway, these are the following remedies which are available, sir. Remedy number one. Now, how this remedy will be provided, sir? It depends on how these borrowed funds were used by the company. Imagine, company is there. This company has taken the borrowings of rupees 5 crores, correct? Of rupees 5 crores for doing the construction, sir. But imagine this money was used by the company to repay its lawful debts. Now, did the company use for construction or to pay their lawful debts, sir? To pay their lawful debts. Then there is a concept of subrogation. Subrogation means substitution, sir. Now can I say company has repaid this money to their creditors. In the place of creditors, who will come? Magnum will come now. So this is what subrogation is. Magnum can claim this money to be subrogated in the position of those creditors. In other words, Magnum will now become a new creditor of the company and now company has to make the payment, sir. So this is first remedy which is available, sir. Second, tracing. Matlab, whatever money as a loan 5 crores Magnum has given to the company, now we are checking whether this money can be traced. Is this money lying with the company, in the hands of the company? Is it there either in the form of any property or in the form of any assets? If it is there with the company, then as a situation may, and again Magnum, you will be able to recover the funds or claims from those particular assets, sir. Matlab, that particular thing you can recover, sir. But can I say this is only possible if that money is lying with the company, sir, or property is lying with the company. Otherwise, you cannot take this money, sir. Similarly, sir, third point, sir. Now, third point is like Nyayam. In other words, if at all company is able to prove, now company means what, sir? Magnum. What they are able to prove? Just, sir, whatever loan we have given to whom? This company. Now, because of this loan, company is getting benefited and we are getting loss. In other words, there is a unjust enrichment. Means justified, not justified, not justified. In other words, company is getting undue advantage, unfair advantage, and because we gave loan to the company, sir. If at all this is proved in the court, sir, at least on the basis of equity, good conscience, judge may allow, court may allow, company to refund the money to whom, sir? Magnum, sir. Can I say this is what we mean by quasi contracts? Can I say actually they are not contracts? Yes, sir, this is actually void ab initio. It is not a contract, but at least on the basis of what, sir? Good conscience, at least on the basis of equity, this could be allowed, sir. So this is one point, sir. Section number 72 Contract Act, if you can remember, sir, Magnum has to prove, prove that this was a money which was paid under mistake, sir. Then also they can recover this money, sir. And fourth, the most favorite. Imagine this is also not possible, this is also not possible, this is also not possible. That means in all these three cases, you are not able to recover from the company. Then last May, you catch the collar of whom, sir? Directors, because they exceeded their authority, sir. Okay, this was the answer, sir. And this was asked for 4 marks. Now let us see 3B2. S&M Limited was registered in 2021. Share capital is 50 lakhs. 5 lakhs equity shares are there as a Section 8 company, sir. For promotion of arts in Jaipur, correct? Company made a huge profits. Now, question is, can a Section 8 company make profits? Answer is yes. Section 8 company can always make profits. There is no problem. Only thing is, whatever profits they earn, again they have to apply for the upliftment of their objectives, sir. Okay. Now, what has happened, sir? On 10th May, 75% of the members demanded to distribute 10% dividend to their equity shareholders by passing special resolution, sir. Is this allowed? 10% dividend and as per Companies Act, is this allowed? Is what the question is. Now tell me, sir. Can I say Section 8 companies and members who are forming the Section 8 companies, you have to give 3 promises. Promise number 1, you will be doing this, you will be forming this company for charitable purposes, sir. Second, first thing is you will not make profits. If at all you are making the profits, that money will be again utilized for the upliftment of your objectives. And third, you will never ever distribute the profits of the company in the form of dividends, sir. If these 3 conditions are fulfilled, then only you can open a Section 8 company, sir. Here what this company is doing, sir, they want to give dividends. 75% members approving by passing SR, they want to give dividend. SR no SARA? Answer is no SAR, not allowed, sir. Why? Because Section 8 subsection 1 clause C में third point which says a company registered under this section shall not pay dividends to its members. So this is not allowed, sir. Can company pay? Answer is no, not allowed. Jitna bhi huge profits you are getting, you cannot declare the dividends, sir. Still you did overaction by declaring the dividend. Then actually they did not ask the consequences, sir, but still I included, sir. Now tell me, sir, you did follow Section 8 ka provisions, sir, or not followed Section 8 provisions, sir? Not followed, sir. Then ऐसे situation में what is possible, sir? Central government who has given you license of Section 8 companies, sir, they may revoke your license, sir. Or there is a possibility they may order you to convert into another form of a company. Why? You want to distribute dividends, no? Then convert yourself either to a private or a public company, then distribute, sir. Or they may ask for what, sir? Winding up also, sir. And penal consequences are also possible for your officers in default, sir. This all will happen if at all dividend is declared, sir. So you cannot declare dividend, sir, even if members give approval, sir. 3C. According to the provisions of Indian Contract Act, define the following terms, sir. Nature and extent of surety's liability. Now tell me, sir, can I say contract of guarantee may we are having 3 parties? One is principal debtor, one is creditor, one is surety. Now can I say there is always a liability between principal debtor and creditor? Now whatever is a liability, now can I say as long as principal debtor is liable to creditor, as long as he is liable to that extent, Mr. Surety is also liable, sir. In other words, principal debtor liable to creditor, surety liable to creditor. This is what I mean by co-extensive liability, sir. In other words, liability of surety is co-extensive with the liability of principal debtor. If principal debtor is not liable, surety is also not liable, sir. Similarly, can I say on due date, creditor, you should first go and recover money from principal debtor. If he defaults, then only you should come and recover money from surety. In other words, liability of surety is always secondary and conditional. Principal debtor is primary and unconditional, sir. So this is the nature of liability of surety. So you can see surety's liability is coextensive. If debtor cannot be held liable, then surety liability also comes to an end. Surety's liability is always secondary in nature, sir. Next. Now we are talking about discharge of surety based on invalidation of contract of guarantee, sir. So surety can be discharged in 3 ways. Now they are asking the third way, invalidation of contract of guarantee, sir. That means what, sir? Whatever contract of guarantee is made, that contract itself is invalid, sir. Now how this contract can be invalid? Imagine surety's consent was obtained by misrepresentation, sir. So can I say contract becomes voidable? As a situation mein surety can discharge the contract, sir. Similarly, it was obtained, guarantee was obtained by concealment. Again, facts were not told, sir. Again, contract is voidable, sir. Or surety gave a promise that he will act as a surety only if another co-surety also joins. And imagine that co-surety did not join. So can I say this surety is also not held liable, sir? In other words, when the time you made him act, when the time he said that he is going to become a surety, he has put one condition saying what? If other co-surety also comes, I will be liable, sir. Now imagine if that person does not come, he is also not liable, sir. So last May, that person did not come, sir. When co-surety did not join, then he will also not join, sir. So these are the circumstances where your contract of guarantee will become invalid. And if it becomes invalid, sir, then surety, your liability will get discharged, sir. 4A. हाँ, कितना लेंथी पेपर है भैया. X was running a business of car on a lease. One fine day, Y came to hire a car for 10 days for his business tour from Delhi to Amritsar. So here we are taking the car on rent. It is not purchase of car. It is taking car on rent, sir. Sir, Honda City was given 50,000 के लिए, it is given 10 days के लिए, it was there, sir. Journey में engine choked, sir. Y has spent 10,000 for repair of engine. When he was coming back, brakes also gone, sir. Can I say because of which accident occurred, he was admitted to hospital, he paid hospital bill of 50,000 rupees, sir. Now can I say Y is asking to X, Raja, because of your Mandbuddhi car, I have incurred 50,000 as a hospitalization expenses and I have incurred 10,000 for repair expenses. So please pay me 60,000. Who is asking this to whom, sir? Y is asking to X. Great. What is X saying? I am not going to make any payment because I was unaware about the engine. And when I am unaware about the engine, neither I will pay you engine repair charges nor I will pay you hospital charges, sir. Y ka ego got hurted, and whenever ego gets hurted, Anna sues whom, sir? X for recovery of damages, sir. Give your opinion with reference to provisions of Indian Contract Act whether Y can withheld the amount of higher charges. Now what do you mean by withheld? In other words, can I say here Y wants 60,000, but Y also has to pay higher charges of 50,000. So he is saying, you are not paying me 60,000. No, I will also not pay you 50,000, sir. He wants to claim set off, sir. Is this allowed? Whether Y can withheld because non-payment of damages? That is question number 1. Whether X was liable to pay damages. In fact, what should have been a better word, sir? This should have been 1, this should have been 2, sir. Anyway, no problem, sir. Sorry, let us answer first part, sir. Can I say, by looking at these facts, what you can understand is it is a non-gratuitous bailment. Correct, na, Raja? Can I say car is a movable assets? Person who is the owner of the car. Who is the owner of the car, sir? X, he is the bailer, and Y is the bailee. And here there is a consideration between them, 50,000, sir. So hence it is a non-gratuitous bailment, sir. Now, whenever there is a non-gratuitous bailment, bailer, oh bailer, Mr. X, you are having a duty. What is your duty? Duty to inform or duty to specify defects in the goods, sir. Now, which defects? Whether it is known defects or unknown defects, sir. Because it is which bailment? Non-gratuitous bailment, sir. Now tell me, sir. Did Mr. X disclose all the faults in the goods? Answer is no. He did not disclose all his faults, sir. That means, did bailer perform his duty? Answer is no. Now, getting the consideration is actually right of bailer. It is actually right of bailer. But can I say, bailer, you will exercise your right only if you perform your duty. You did not perform your duty, you cannot exercise your right, sir. So in other words, bailee, what you can do, when bailer is not exercising his duty, then you need not perform your duty also. What is bailee's duty, sir? To make the payment. It's simple logic, Raja. One person's duty will be another person's right. Getting the higher charges is right of bailer, duty of bailee, sir. Now can I say, bailee, you need not perform your duty because bailer did not perform his duty, sir. So when bailer did not perform his duty, you also need not perform your duty, sir. So that is what it is written. So can he withhold the money? Answer is yes. Section 170 to 171. Bailer is entitled to claim compensation from the bailer if loss is caused due to bailer's breach of duty. Correct है? What is the duty of the bailer, sir? Bailer का duty was to disclose all faults. Now, when I say all faults, it could be known, it could be unknown, because it is non-gratuitous bailment. It is a bailment for hire or reward, sir. Y has suffered loss, hence you have to compensate, sir. So hence Y has a valid legal right to claim compensation, sir. So here 150 ka reference also I have given, sir. So what is this 150 talking about, sir? Ki whenever there is a bailment of hire, bailment for hire, sir, it is nothing but non-gratuitous bailment, sir. Mr. Bailer, you have to disclose every fault, sir. You have to disclose every fault which is going to materially interfere the use of them or expose bailee to an extraordinary risk, which you did not, sir. Hence you are liable, sir. Now, whether X is liable to pay damages? Yes. Can I say 50 plus 10, 60,000 you have to pay, sir. And you have to do this. So, X is liable to pay damages even if he was unaware about the faults. Gratuitous bailment, you should only disclose known faults, but non-gratuitous bailment, you have to disclose every fault, sir. Hence, bailer is absolutely liable regardless of the knowledge or ignorance, sir. Done. 4B. Again, subdivision, sir. Delivery of instrument is an essential whether instrument is payable, bearer or order for effecting the negotiation. Now, can I say negotiation is defined in section 14 of Negotiable Instrument Act. What do you mean by negotiation, sir? Can I say whatever negotiable instrument is there, that negotiable instrument ko you want to transfer it to any person. Transfer matlab you are having right to receive money. That right you want to give to others. That if you are trying to give to others, that means you are negotiating the negotiable instrument, sir. In other words, if your rights you are giving to others, then that is called act of negotiation. That is called as what, sir? Act of negotiation, sir. And that act of negotiation ke liye, what is very, very important? Section 46 talks about delivery is very, very important. For example, if it is a bearer instrument, sir, bearer instrument ko, if you want to negotiate, then it is allowed by only mere delivery. What is not allowed, what is not required? Endorsement is not required, sir. But if it is a order instrument, endorsement plus delivery you have to do, sir. Whatever it is, whether it is bearer, whether it is order instrument, here also delivery is important, here also delivery is important, sir. That means for negotiation, delivery of instrument is very, very important, sir. That means if delivery does not happen, negotiation does not happen, sir. I hope this point is understood, sir. And next question, very, very straightforward, sir. Promissory note, bill of exchange, sir. Can I say as it is, I copy pasted from the textbook, sir. Can I say promissory note mein only two parties are there, sir? Maker and payee. Here three parties are there, sir. Can I say promissory note mein acceptance is not required, sir? But can I say here two times presentation will be done. One is presentation for acceptance, presentation for payment, sir. So here presentation of acceptance we are talking about, sir. So you can just quickly go through, sir. Straightforward, hence I don't want to discuss much about it. Similarly, 4C also is a straightforward question, sir. You have to write some functions of Ministry of Finance, Corporate Affairs, Law and Justice, sir. You can copy from the textbook, sir. Next, let us see 5A. Already video is for 1 hour 18 minutes. Okay, first question, sir. P sold certain antique items to Q for 3 lakh rupees on 13/12/2024. As per the terms of agreement, 75% of the amount was to be paid within a week and balance 25% was supposed to be paid till 31st December. Okay. So here P has sold certain antique items, sir. 3 lakhs ko it is sold, 13/12 ko it was sold, sir. 75% amount is paid, 25% will be paid till 31st December, sir. Q appointed agent R to take the delivery of the goods after the payment of first installment. So first installment is paid, sir, on 18/12, sir. Great, which was credited on the same day. But can I say that Mandbudhi agent did not go and collect the item, sir, due to some medical emergency, sir. Now, can I say in between what has happened, sir? Second installment ka due date came, which was 31st December. 31st December over, 10/1 also over, sir. And still the 25% is not paid. But on 10/1, who is coming, sir? Agent is coming and asking for delivery of goods. Now, can I say Mr. P wants to refuse to delivery of the goods and exercise his right of lien over the goods. According to the provisions of Sale of Goods Act, give your opinion whether P was justified in exercising the right of lien as only 20,000 was left. Now, Bolo Raja, what should be the answer? Can I say here the concept of unpaid seller will come into picture? Meaning, here unpaid seller matlab kya, sir? Is he receiving the money or yet to receive the money? Yet to receive the money, sir. Now, actually he is supposed to receive 3 lakhs. In that 3 lakhs, 2.8 he has reserved. Only 20,000 is pending, sir. Is he still an unpaid seller? Answer is yes. Because you will be unpaid till the final total amount is paid, sir. Even if part amount is paid, sir, still you will be regarded as an unpaid seller, sir. As per section 47, sir. So, देखो. Now, facts I am not reading, sir, because same question it is, sir, but in a more presented format, sir. As per section 47, unpaid seller of the goods will have a right of lien, sir. That means unpaid seller, you can exercise right of lien. But question is whether, when you will be called as an unpaid seller, sir. You will be called as an unpaid seller if 2 conditions are fulfilled, sir. Good. Sorry. So, first question is when you will be called as an unpaid seller, sir. Sir, you will be called as an unpaid seller even if part of the price is not paid. So, can I say in this case part of the price is not paid? So, are you an unpaid seller? Yes. As per section 47, if you are an unpaid seller, you will have right of lien, sir. Okay. Next, you can exercise right of lien only if 2 conditions are fulfilled. Condition 1, goods ka possession is not delivered. Correct? Seller is still having the possession of the goods and whole or part of the price is not paid. Whole to nahi, part is still not paid. Can I say both the conditions are fulfilled? Yes. You can see in between and is there, and in our case also possession is still with us, 20,000 is not paid, hence I am an unpaid seller. If I am an unpaid seller, I will exercise right of lien, sir. So that is allowed. So you are legally justified in exercising right of lien even if 20,000 remains unpaid, sir. Okay, now this was again a tricky question, sir. Maybe different people will have different perspectives, sir. So this answer I will not take full assurance, but as far as I am concerned, according to me, this is the best answer which I am providing, sir. An auction takes place in Delhi for antique items. Very good. So here we are talking about auction sale, sir. It is notified to the bidders that sale will be completed only when the hammer of the auctioneer hits the table and he announces you are the highest bidder. Okay. So question is clearly saying when sale will be complete, first he has to hit the table. Matlab, auctioneer has to hit the table with hammer, sir. Plus, and is written, sir. Plus, he has to announce you are the highest bidder. Very good. During the auction, L bids for antique sculpture worth 8 lakh rupees. The hammer falls. Acha, hammer also falls. 1, 2, 3. But announcement cannot be made as the auction suddenly stops before the auctioneer could utter any words. Wow. So he has, what do you say, put the hammer, sir. He has hit the table with the hammer, sir, but he did not make the announcement, sir. Is the sale complete? Answer is no. Acha. Now, why this entire thing happened, sir? Why this did not happen? It was notified to everyone that there is an unexpected rise in the market price for that particular sculpture and therefore it could not be sold on that particular day. Whose ego hurted? L ka ego hurted, sir, because he was the one who who participated in the auction, sir. So L contend that auctioneer is bound to sell the sculpture to him at the price he bid because once he bids at the highest price in the auction, the hammer fell, the auction sale was completed. Which is no, I told you, auction sale will happen when 2 things are there, sir. One, hits the hammer, plus he should say, utter with his words, you are the highest bidder, sir. discuss the validity of L's claim. Who is L here? The person who is participating in the bid, sir. Now tell me, sir, do you think L will have any claim in this part? Answer is no. He will not have any claim, sir. Let us see the answer, sir. Section 64. Now, subsection 2, directly I am referring, sir. A sale by auction is complete when the auctioneer announces its completion by fall of hammer or in any other customary manner. Now, here, can I say you can understand by their customs, fall of hammer is also required, announcement is also required, sir. Fall of hammer occurred, but announcement did not occur. Hence, sale is not complete, sir. So, until such announcement is made, any bidder may retract, correct? And auctioneer can also withdraw, sir. Yes. So, now tell me, sir, what are the terms of the contract, sir? So, it was pre-notified. That means both the parties, everyone knew about it. What they knew about it? Ki bhaiya, sale is going to happen when both the conditions are fulfilled, sir. So, hammer should fall, auctioneer should say you are the highest bidder, sir. So, this was the customary manner for completion of sale, sir. So, here, was this custom followed? Answer is no. So, L was the highest bidder. Hammer fell, but the customary declaration that you are the highest bidder was not made. Hence, and in between, auction was paused and sculpture was withdrawn, sir. Is this allowed? Yes. Can I say offer can be revoked before the acceptance? Here, acceptance is not made, and who has to make the acceptance, sir? Can I say the auctioneer, sir? The sale was not complete since the customary manner was not fulfilled. Hence, there is no contractual obligations. Hence, L's claim is not valid because sale was not completed, sir. That's it, sir. 5B. A partner indeed virtually embraces the character of both principal and agent. Correct? Can I say if you are a partner, you will be playing dual role. Sometimes you act as a principal, sometimes you act as a agent. The implied authority of a partner to bind the firm by all the acts done by him in all manner connected with the business is done in the usual way, not beyond the nature and scope of the partnership. Explain with reference to the above acts. So, can I say 18 plus 19 we have to refer, sir. So, can I say 18 is talking about partner as a agent. Always remember, Indian Partnership Act is recognizing a partner under a dual position. Means sometimes you are a principal, sometimes you are a agent, sir. Now let us see partner as a agent. A partner will be called as an agent of the firm, sir, when for the purposes of businesses of the firm. In other words, whenever a particular partner is doing any business of the firm, at that time he will be called as a partner, he will be called as an agent. Firm will be called as a principal. When I say firm is nothing but collection of partners. So other partners will become principal, the acting partner will become an agent, sir. So can I say other partners are principal, acting partner is a agent. So sometimes partner is a principal, sometimes partner is an agent, sir. Each partner acts on behalf of the firm. Any act done by a partner within the scope of partnership business binds the entire firm. Entire firms means what, sir? Other partners. So there is an implied agency, sir. Thus, a partner is both a principal and a agent, sir. Then they are talking about what, sir? Implied authority. Can I say 19.1? If you are a partner, you are having some implied authority. What is the implied authority? You can bind the firm by your accessor. Now, this type of activities can be purchase or sale of goods, hiring employees, receiving payments, issuing receipts, borrowing money, sir. So, all these are implied authorities. In other words, we need not tell, still partner can enjoy these rights, sir. But these implied authorities can also be restricted by entering into an agreement, sir. However, 19.2 is talking about what, sir? Those acts which are beyond implied authority, sir. In other words, these type of activities automatically you cannot do, sir. If you want to do this type of activities, you should be authorized. In other words, these type of activities you can do by default, even if partnership agreement does not say anything. You can do it, sir. But to do this type of activities or to do this type of performance of this type of activities, expressly in partnership agreement, this should be mentioned, sir. In other words, nothing said this you can do, nothing said this you cannot do. If it is said you can do, then only you can do, sir. That's the reason they are acts beyond implied authority, sir. So submitting distribution to dispute to arbitration, sir. Opening a bank account in partner's personal name, sir. Compromising or relinquishing a claim, withdrawing suits, transferring firm's property. These are all very detailedly discussed in our classes, sir. So generally, partner, you cannot do 19 subsection 2 wala activities. Even if you do it without express authority, then firm is not bound to this particular things, sir. So scope and nature of partnership business. The partner's authority is limited to the acts connected with the business of the firm. So whatever business of the firm you are representing, that is allowed. Outside that, if you do, then firm is not bound, sir. 5C. Give your opinion with reference to provisions of Indian Contract Act. Whether joint promissor and promisee. Can I say joint promissor के लिए section 42, joint promisees के लिए 45. Can they voluntarily discharge their obligation even after a death, sir? Now tell me, imagine P1, P2, P3 are joint promissor. Imagine if P1 dies, sir. Can P2, P3 discharge the debt, sir? Bolo Raja, can they discharge their obligation? Answer is yes. Can I say 42 May, we studied something called devolution of joint liabilities. What it says, if all the joint promissors, if all the promissors are alive, then all the promissors should perform their responsibilities. That is, perform their performance, sir. If one, or I'll just write this in a proper manner, sir. So P1, P2, P3, if they are joint promissors, if all three people are there, then all three people have to participate in the performance. Rule number 1. Imagine P2, P3 is alive, P1 died, sir. Then ऐसे situation में P2, P3 along with, these are called surviving promissors, along with legal representative of deceased promissor has to fulfill their obligation. If all the promissors also die, sir, and everyone dies, then can I say legal representative of deceased promissors has to fulfill their obligation. So answer is yes. Whether joint promissor can discharge their obligation, yes, as per 42 it is allowed. And same rule is given for promisee also, sir. Even promisee can also demand the performance. Section number 45. So this is devolution of joint rights. This is devolution of joint liabilities. That is there, sir. In case, so you can see here 42 and 45 I have mentioned, sir. You can pause the video and watch this particular answer, sir. In case they won't be able to discharge their obligation. In case they won't be able to discharge their obligation. In other words, one of the partner is not able to fulfill their obligation. Whether any of the joint promissor may be compelled. Can I say for that section 43 May we have studied 3 rules, sir. Rule number 1 was saying what, sir? If at all any of the promissor, sorry, section number 43 May, rule number 1 is saying what, sir? Promisee can demand the performance from any one of the promissor or all of the promissors. So answer is over. Whether any one of the joint promissor may be compelled, answer is yes. Can I say 43, section 43 May, point 1 is giving right to that promisee, sir. What is the right, sir? Ki promisee, you can demand the performance either from one of the promissor or all of the promissors. In other words, jointly and severally liable, sir. So is this allowed? Answer is yes. Section 43. So yes, a single joint promissor may be legally compelled, sir. What would be the situation in case of default of any of them, sir? Now, can I say default occurs, sir, not paying, sir? Then 43 May he, second right is also there, sir. If at all there is a default, sir, then what should happen, sir? Can I say other joint promissors has to participate, sir? So dekho, if one of the joint promissor defaults, that is fails, as per section 43, the remaining promissors must share the defaulted liability, sir, and that too equally, unless agreed. Now here equally does not mean equal share. Equally means both should participate, sir. If one joint promissor pays more than his share, he can recover the excess amount from the defaulter, sir. That is allowed, sir. So 43 was asked in this particular part, sir. Next point, sir. What are the effects of coercion, sir? Now tell me, what are the effects of coercion? Can I say this answer we divided into 3 parts? Can I say Effects of coercion. Section 19. Contract becomes voidable at the option of aggrieved party, sir. Section number 64, sir. Can I say whatever money has been taken by the aggrieved party, he has to return it, sir. Section number 72. Whatever benefit is received by the benefited party, sir, he also has to refund it, sir. Can I say section 72 is clearly talking about money paid under mistake or by coercion, sir. So you can see here 19, 64, 72. So these are the effects of coercion, sir. Aggrieved party, you have to restore the benefit, sir. And any benefit is received by the benefited party, can I say he must also return, sir. And contract will become voidable. That means you can accept the contract or you can cancel the contract, sir. Over. And just for better understanding, we mentioned the coercion definition also, sir. Because this question was asked for 2 marks only, you need not write this in the exam, sir. This is just for your understanding. You could write effects of coercion, that was more than enough, sir. Now we are talking about 6a. Now, very beautiful question hai. Now what I will do is, this time I will just read the facts of the cases, sir. More or less same thing it is, sir. So, better I'll read the section. Under section 130. Okay, facts I did not write for this particular answer. Sir, so let us read the question only, sir. Ram purchased a second-hand car from his friend for rupees 5 lakhs on 10th November. Sorry, 7 lakhs, 5 lakhs के लिए car is purchased, sir. He paid 4 lakhs immediately and in future he will pay 1 lakh anta. Great. But he could not pay the remaining amount till December 2023, sir. Okay. Can I say 1 year में Anna said he will pay. So November 2022 means what, sir? 9th November 23 tak he was supposed to pay. December 23 over, still he did not pay, sir. Great. On 5th January 2024, and Ram, who purchased the car, sir, he received an invitation. Invitation for Rohan's wedding. Can I say Ram received an invitation for the Rohan's wedding, which he could not attend, but sent a check of 51,000 as a gift by post, sir. Wow. So can I say Mr. Ram, who purchased the car, he received a marriage invitation of whom, sir? Mr. Rohan. Anna could not attend that wedding, sir. So Ram is giving a marriage gift of kitna? 51,000. Can I say life mein this type of friends are required, sir. Very good. So Anna has given a check of 51,000 rupees as a gift, sir. And that check was given by post. Very good. Now because Rohan received it, sir, he deposited the check. But the check was bounced. That means it returned as unpaid and the reason for bouncing was insufficient balance. Can I say now this type of friends are not required in life, sir. एक वक्त में जज्बात बदल गए, हालात बदल गए. Till now I was saying what, sir? This type of friends are very good, sir. But can I say these mandbuddhis are only giving check, but check is always getting bounced, sir. Now the question is, Rohan is considering this as a offense under section 138 of the Negotiable Instrument Act, sir. Now you have to give advice whether Ram would be held liable for dishonor of check, whether Rohan was justified in considering this as a offense under section 138. Again, what could have been a better question, sir? This should have been 1, this should have been 2. Because if Rohan is justified, then Ram will be held liable for dishonor of the check, sir. Anyway, let's go forward, sir. Now remember, sir, to incur liability under section 138, sir, we have to fulfill this all 5 conditions, not any, all 5 conditions, sir. What are those? First condition, sir. Can I say check must be drawn for discharge of legally enforceable debt? Now tell me, sir. Can I say who gave check? Ram. Ram के नाम पे कलंक है ये व्यक्ति. So Ram issued a check to Mr. Rohan. Check value is 51,000, sir. Now tell me, sir, why did Ram give this check to Mr. Rohan, sir? Just as a gift. Remember, he did not give this check for the consideration, sir. है ना. For that he did not give, sir. This check he gave as a gift, sir. So can I say, when I said all conditions should be fulfilled, sir, condition 1 itself is not fulfilled. Remaining I need not check, but anyway for your ego satisfaction I will read it, sir. Next, that check must be presented within 3 months. Here we are assuming that he did that, sir. Check is returned unpaid due to insufficient funds. Yes, in this case this happened. Then payee must give a written notice to drawer within 30 days of the dishonor, sir. That means you have to give this notice ki Anna, check is returned, I am giving you, sir, I am asking you to make the payment, sir. So this written notice you have to send within 30 days of dishonor, and next 15 days में, है ना, within 15 days Anna has to make the payment, sir. Assuming that these all conditions are fulfilled, sir, only first condition is not fulfilled, sir. Still, can I say remedy under section 138 is not available, sir. So Ram is not liable under section 138 because the check was not issued for a legally enforceable debt. That is, condition 1 is not satisfied, sir. Next, tell me, sir, when can I say Ram is not liable? Is Rohan justified in considering this as an offense? Answer is no. Rohan not legally justified in treating this as a offense. Okay, done. Next, 6b, sir. With reference to provisions of Indian Contract Act, define quasi-contract and salient features of quasi-contracts. Now, quasi-contract matlab kya, sir? These are not real contracts which parties are entering between them. Or you cannot say if these are those contracts which will have all the essential elements. That means offer, acceptance, consideration, capacity. All these things are required for forming a valid contract, sir. So quasi contracts, these are such contracts which are implied in the eyes of law, sir. These contracts may or may not have all the essential elements. And remember, if they have all the essential elements, then why should we call this as a quasi contract? So definitely some of the essential elements will not be there, sir. But still, law wants this to be called as a contract. Hence, they are contracts implied in the eyes of law. They are not contracts, but they are in the nature of a contract, sir. And all these quasi contracts are based on the principle of equity. What is this equity, sir? That is nothing but what, sir? Doctrine of unjust enrichment. That is, no person should grow at the expense of whom, sir? Others. So this is the meaning of what, sir? Quasi contracts. So they are not contract in the strict sense, but they resemble like a contract, sir. Law is imposing obligations on the parties, sir. So this is quasi contract, sir. And you have to write some features. 3 features are there in our textbook, sir. So quasi contracts may you will be always having right to receive the money or sometimes liquidated sum of money, sir. And that right you are getting not by virtue of any agreement, but it is imposed by law. And that right you are having against a particular person only, but not against the entire world, sir. That is just in personam and not in just in rem, sir. So that is what it is, sir. Next, explain the following terms with reference to Indian contract. Pledge by mercantile agent, pledge by persons in possession of voidable contracts, sir. So generally, what is this answer talking all about, sir? If you are a owner of the goods, then only you can do the pledge. But this is a general rule, sir. For that exceptions, in that exceptions, these are the 2 exceptions, sir. So here, because it was a direct answer, sir, I don't think I have to discuss much about this particular thing, sir. So, in this one more answer is also there. Responsibilities of finder of goods, sir. So what is the responsibility of the finder of goods, sir? First thing is you have to take reasonable care of the goods, sir. First point, sir. Second point is what, sir? You should not misappropriate that goods, sir. And third, when you find the real owner, you have to return the goods, sir. That is a point, sir. Now, pledge by mercantile agent, sir. So, is mercantile agent a owner or non-owner? Non-owner, sir. So, here pledge is happening by non-owner, sir. So, can mercantile agent do the pledge? Answer is yes. Condition, first, he should be in the possession of the goods. Second, he is doing this with the consent of the owner. Third, this pledge will be valid if pawnee acted in good faith and had no notice that the pawner had no authority to pledge. Here, who is the pawner, sir? Pawner is nothing but that mercantile agent, sir. So, if these 3 conditions are fulfilled, sir, then this pledge by non-owner is allowed, sir. Similarly, if any person is having any goods under a voidable contract, is this pledge also valid, sir? Answer is yes. Condition is, sir, he should have not rescinded the contract, plus whoever is the pawnee, sir, he has acted in good faith, plus he is not having the notice of the defective title of the pawner. If these conditions are fulfilled, sir, here also, even though you are not a owner, sir, still this pledge is valid, sir. Okay, done. 6C, with reference to the provisions of, when it will get over, last minute. Okay, with reference to the provisions of Sale of Goods Act, answer the following, sir. Can I say the time which you have taken for writing the answer, that much time I have taken for discussing the answer, sir. Chalo, great. With reference to provisions of Sale of Goods Act, answer the following. What do you mean by reservation of right of disposal, sir? That means what, sir? Section number 25 of Sale of Goods Act, sir. In other words, seller has sold the goods, but seller is saying that you will get the ownership only if certain conditions are fulfilled. In other words, he is still reserving some rights with him, sir. Even though possession might have been given to you, still you will not become the owner. Some rights are still with me, sir. If that type of situation occurs, we will say what, sir? Reservation of rights of disposal are there with whom, sir? Seller. Now, why these rights are available with seller, sir? Because we are protecting whose interest? Seller's interest, sir. So that is the logic, sir. Next question is, under what circumstances rights of disposal may be reserved, sir? First is, can I say this is expressly written in the contract, sir? Then rights of the reservation of rights of disposal will be there with whom, sir? Seller. Or bill of lading or any lorry receipt, railway receipt is sent, but it is on whose name? Seller's name, sir. Generally it should be on whose name, sir? Buyer's name. But here it is on whose name? Seller's name. It is assumed that seller wants to reserve the right of disposal, sir. Or can I say seller has sent the goods now by, maybe can I say by ship or by any railways, etc., sir. Now when he has sent the goods, obviously what he has done, sir, he has prepared a bill of lading or railway receipt, sir. Along with that, he has also prepared one bill, sir. He has drawn a bill, sir. Bill of exchange, bill drawn, sir. So he is giving you bill of lading also, bill of exchange also. Remember, this bill of lading or railway receipt is on whose name? Buyer's name. Second point, it is on whose name? Seller's name, sir. Now, bill of lading is also prepared, plus bill is also drawn and sent to you, sir. Why it is sent to you? So that you can accept it and then give it, sir. Now imagine, sir, if you don't accept the bill, sir, you don't become the owner, sir. So as a buyer, what is your duty, sir? Take the goods, sign, accept it, and then give the accepted bill to whom, sir? Drawer, nothing but seller, sir. But imagine a scenario. If you don't accept it, sir, then what should buyer do, sir? He has to return the bill of lading, sir. In other words, who will be the owner? Seller will be the owner, sir. But imagine buyer very cleverly what he does. He keeps the bill of lading also with him, sir. Then law says property in the goods will not be transferred to you, sir. So that is what it is, sir. Next, anything else? Yeah. Second question, sir. Sometimes breach of condition will be treated as a breach of warranty. Now remember, sir, breach of condition, breach of warranty. Now breach of condition gives you a wider right. What is that, sir? You can cancel the contract and claim the damages, sir. But breach of warranty may, you will only claim the damages. You don't have right to rescind the contract, sir. So sometimes breach of conditions will be treated as a breach of warranty, as a result of which buyer loses his right to rescind. Correct? Just now I told you, sir, you cannot cancel the contract, but you can claim only damages. Now you have to tell me those circumstances where you can do this, sir. Now obviously this is for 3.5, this is for 3.5 marks, sir. Okay. So what are the three situations, sir? Situation number one. Can I say voluntarily buyer is waiving the conditions, or voluntarily buyer is electing breach of condition as what, sir? Breach of warranty, sir. Allowed. And if the buyer has accepted the goods, he cannot. Now who has accepted the goods, sir? Buyer has accepted the goods. Matlab he started using the goods, etc. Then ऐसे situation में Mr. Buyer, understandable, you purchase the goods based on certain conditions. They were very, very important stipulations. We understand. Why did you use the goods? Can I say, जैसे you use the goods, indirectly it proves that है ना, you want to claim the ownership, sir. And if you want to claim the ownership, now contract will not be voidable, sir. In other words, you cannot rescind the contract. Yes, you can still claim for damages, sir. Or where the contract is non-severable and partly performed, sir. In other words, here what has happened, sir? Contract is not separable, okay, in which part performance is made, sir. Then ऐसे situation में है ना, you lose the right to rescind. एक beautiful example we could have taken, sir, but anyway it is getting very lengthy now, sir. So these are the questions which were asked in your exam, sir. So this was the analysis. Sorry, sir, some disturbance it was. So this was the total question paper, sir. Now let us try to see the observations, sir. So these are all my observations, sir. Totally 24 questions were asked. 24 questions got sick. Wow. Can I say, matlab, people who studied in Andhra Pradesh or Telangana, sir, can I say 12th class mein, we used to, 12th matlab intermediate second year we are talking about, sir. Economics paper used to come, sir. Sir, that paper was like a Mahabharat paper, sir. Matlab, itne questions were there, sir. You used to never get any time to complete the paper, sir. That type of paper has become your CA Foundation law paper, sir. In fact, to some extent, I observe that CA inter paper was less lengthy compared to this particular thing, sir. Because there at least 30 marks will come for MCQ. Here everything is theoretical, sir. So 20 questions you are supposed to answer. This makes paper lengthy and time management will be very difficult. So how you have to solve this particular problem? Obviously problem, I should not tell you how to solve this, sir. So whenever you are attempting for this type of paper, sir, what you have to do is before the exam, sir, you have to take some mock papers. Imagine, can I say you can take this question paper now and try to solve this particular paper by putting a timer, sir. Put 3 hours ka timer, sir. Create that type of exam environment during your this thing, sir, and then try to give the answer, sir. If you are able to give, can I say you are able to do that, sir. So practice is very important here, sir. Next. Sir, all the questions, most of the questions were what, sir? Application based, and because of this, questions become tricky. Now, part was, is this a tough paper, sir? I will not say it is a tough paper, sir. You know, because some questions were manageable. At least 50 to 60 marks were manageable, sir. 40 marks, obviously you're writing a CA paper, not a BCom paper, sir, where you should be getting all easy questions, sir. So it was that type of a paper, sir, where an average student can also secure his marks, sir. And now, strange thing was what, sir? Contract Act mein Unit 1, Unit 3, Unit 5, say complete questions were ignored. Sir, focus was only on what, sir? Special contracts. But that doesn't mean every time will happen like this, sir. This time it happened like this. Every time we don't know, sir. Similarly, Partnership Act mein, sir, somewhere around 21 marks came. Now that analysis also I have prepared, sir. You can see here, Indian Partnership Act mein 3 units are there. Unit 1 ignored, Unit 3 ignored. Total 20 marks questions were asked from unit number 2 only, sir. Similarly, Contract Act mein Unit 1 ignored, Unit 2 ignored. 3 में से Unit 3, it's a very big unit, sir. Only 2 marks question came, sir. That coercion wala question, sir. Unit number 4 से only 1 question came for 5 marks, sir. Unit 5 was completely ignored. 6, 7, 8 are, sorry, 7, 8, 9 are special contracts. And if you can see, sir, almost 26 marks came from special contracts, sir. You know? So this was one particular observation which you have to go, sir. Sale of Goods Acts may, can I say, every chapter, every unit say question was asked, sir. And 21 marks was the part, sir. LLP, very small chapter, 6 marks, sir. Companies Act, 21. Negotiable Instrument Act, 14 marks, sir. So people who are writing the coming paper, sir, my sincere advice would be what, sir? When you are studying, study everything, sir. But when you are studying before the exam, sir, when you are preparing before the exam, sir, your first priority should be Companies Act, sir. Second priority should be what, sir? Special contracts, sir. Third priority should be what, sir? Partnership Act. Fourth priority should be what, sir? Sale of Goods Act, sir. Fifth priority should be your Negotiable Instrument Act. Sixth priority should be your this contract, sir. And last priority should be your Indian Regulatory Framework, sir. Like this, you have to study. Again, I am telling you, sir, I am not asking you to ignore unit number 1 to unit number 6, sir. I can understand. Can I say 74 sections, 75 sections you have to cover in this particular part, which is very important, sir. But sometimes you have to do exam study also. So know everything, sir, but while preparing for your exam, you have to prepare in this particular manner, sir. Okay. So this was our analysis, sir. Now, these are our social websites, these things, sir. If you feel you want to connect with us, then these are the platforms where you can connect with us, sir. So this is our YouTube channel. Subscribe to our YouTube channels for more of such videos, sir. And if at all by chance you are having your CA inter students as your friends, sir, May 2025 का भी detailed analysis video I have uploaded on my YouTube channel. So you can click on this particular link, or you can also scan this QR code, sir. So thank you very much for your cooperation. फिर मिलेंगे चलते चलते, sir. And if at all somebody wants to buy my classes, sir, for CA Foundation, all the recorded classes are available on my app, sir. So you can scan this particular app, scan this particular QR code, sir, and you can download the app. You can buy the classes immediately and start using them, sir. Okay. So thank you very much, guys. See, फिर मिलेंगे चलते चलते, sir.